Hi, everybody. Welcome to our CLE on expungement in Tennessee. My name is Brianna Murphy, and I'm a law clerk at Tennessee Justice Center. This is being recorded August 1st, 2024. And we're so glad that you are interested in this topic and hope that this presentation is helpful for you. So first, a short overview of what we'll be covering today. First of all, what is expungement? We'll go over why expungement matters. We'll go over specifically expungement in Tennessee, which interestingly is called expunction in the state statute. And we'll go through the process of what it looks like to go through expungement, give some examples, and briefly talk about what it might look like to plan a whole expungement clinic. First of all, what is expungement? Expungement generally removes a criminal charge or charges from a person's criminal record. And when a Tennessee court expunges a person's charge, the public records related to that are destroyed. So we want to think of expungement not as a complete eraser, because public records do not include arrest records, investigative reports, TBI or other government agency intelligence information, or DA records. So it's not a complete eraser. This information that gets expunged is just not available to the public. And as I mentioned, in Tennessee, the statute on expungement is called expunction. Why does expungement matter? Expungement is an extremely important tool to use when looking at re-entry into society after incarceration. Or possibly not after incarceration, after any kind of charge on your record. But it's particularly powerful in a situation where somebody is re-entering society and wanting to regain as full of a citizenship right as they can. So expungement can help with things like employment and professional licensing, housing and education, loans, benefits such as food stamps and Medicaid. In Tennessee, that's called SNAP and TennCare, child welfare, military service, voting, and of course, there's just the social stigma that it helps with. So after expungement in Tennessee, no collateral consequences of the charge or the conviction may continue, and a person does not commit perjury if they deny the charge or conviction under oath. So this is part of that trying to unravel what public record is. So even though after expungement, for example, a DA could still see a charge on somebody's record, if that DA asks about it in court and the person who has been expunged says they did not do it, they are not committing perjury under oath. And that's in 4032-101G, which is part of the statute that we will be talking about much more as we continue. So expungement is a great first step towards restoring somebody's citizenship rights in Tennessee, but the full extent of citizenship restoration rights requires extra steps in Tennessee. And so that's not something that we'll be fully covering in the CLE. There's just not time. The statute is too difficult to parse alongside the expungement statute, which is difficult enough to parse as it is. So if you're interested in that, I encourage you to do some research, find some CLEs outside of this one. This one will just be focusing on expungement. So let's get a little bit of the lay of the land here. Some statistics that are out there. There are not many statistics out and about expungement in the United States, and even fewer state by state. But there are a few places where our data has been collected. So the CCRC is an organization that collects some of this expungement data and has some state by state data. So According to the CCRC, Tennessee is 31st in state restoration laws. So we're not very high up there in terms of their ranking. According to Rosenblum law, we are the fourth toughest to clear a criminal record. And toughest just means the number of barriers, the amount of paperwork, how clear the forms are for somebody, whether somebody is able to do this pro se or if they need the help of an attorney or somebody who's been trained. So the Rosenblum law data suggests that Tennessee is the fourth toughest state in the nation to clear a criminal record. And in Tennessee, there is a waiting period depending on the conviction. There is a 5 to 15 year waiting period after the sentence has been served before you can submit a petition for expungement. And this graph on the right is from a University of Michigan School of Law study that was published in the Harvard Law Review in, I believe, 2015. All of these sources are linked at the end of this presentation, and you'll be provided with the sources as well if you are interested in delving deeper into them. But so this study from University of Michigan School of Law looked at the average number of expungements after a 5-year waiting period. They looked at the period of time between the 1960s in 2014, so this is actually Michigan data, but just to get a sense of what might be happening in other states. The number of expungements that actually happened is represented with that black column, and the total eligible population is represented with that gray column. So as you can see, the number of records that are actually getting expunged are likely similar here in Tennessee, way lower than what is possible, than what we could be achieving with a absolute right that's provided in the Tennessee statute. So let's move on to the general process of expungement. So again, we're starting by looking at 4032-101G. And the expungement statute overall is 4032-101. So G authorizes Tennessee courts to grant expunction of misdemeanors, Class E felonies, some Class C and D felonies, and some crimes committed before 1989. So this is very specific to the statute. G provides a list of crimes. And the thing about the expungement statute in Tennessee is that it lists most things in the negative. So you'll find a list of what is not eligible for expungement rather than what is eligible. So as you're looking at the statute and when you're working these cases, make sure you take note of whether the part of the statute you're looking at is talking about things in the negative, as in these crimes are not eligible, versus the positive that this is a list of crimes that are eligible, because it does go back and forth. So just make sure that you are paying attention to which of those buckets you're in as you're parsing the statute. Just a note that DUIs are ineligible for expunction in Tennessee. These cannot come off of your public record. So if you see them on a client's record, just know they're not eligible, they're not coming off, but they're also not going to block other convictions from being expunged. We'll explore this more in detail a little bit later. So just a general overview of how expunction works. First, we have to figure out if the conviction or the charge is eligible for expunction. And this involves an in-depth analysis, but it involves looking at the jurisdiction that it's in. So you have to submit petitions in the jurisdiction to the court in the jurisdiction where the conviction is from. Expungement may require that costs are paid, and when working with clients experiencing poverty, it is possible to submit an affidavit of indigency to the court, and statewide there has been varying amounts of success in terms of whether courts will waive all these costs or not, but that always is an option. And for clients experiencing poverty, it's an important option to take advantage of, to submit that affidavit of indigency and make sure that it's at least before the court as a matter of consideration. So after all costs have been paid, it can move to the petition process, which is the actual paperwork you submit to the court. Generally, you will also attach a costs sheet showing that there are no outstanding costs. And then there is a rebuttable presumption in favor of expungement. So the court will look at it with a presumption in favor of expunging your client's record. The DA, if they choose to, can present evidence if they think it's appropriate to suggest to the court that a record should not be expunged, but there is a very strong presumption in favor of expunging convictions in Tennessee. And expungement in general in Tennessee. We'll get to some different buckets of expungement in just a moment. One last note before we move on, there is no automatic record clearing in Tennessee. So in other states, sometimes if a charge is dismissed, the charge will be expunged automatically, or even in a handful of states, once your sentence is served, that charge will be expunged from your record automatically. Tennessee is not one of those states. So there is no automatic record clearing in Tennessee. There is mandatory relief on request for dismissals of charges. So dismissal expungement is one of these buckets we'll be talking about. And there's mandatory relief for that. So if you have dismissed, if you get a client's criminal history and there are only dismissed charges on it, all of those are expungible without costs, most likely without costs. And there's mandatory relief for those. And as I was saying, there is a rebuttable presumption in favor of conviction expungements, which is another one of those buckets we'll get into very shortly. So let's talk about these buckets of expungement. There are three main buckets, and we've touched on two of them already. So there's the dismissal bucket, which can show up in a number of different ways on criminal histories. It can show up under 4032-101A1. We've got dismissal, no true bill, no charge, or charge abated by death. And just a note that under C here, if there's a mistaken identity involved in the charge, the expungement may be expedited. But again, even in cases of mistaken identity, there is no automatic record clearing. You have to go through the expungement process. It might be expedited, but you still have to do it. A dismissed charge may also show up as a not guilty verdict. The judge has to ask if the defendant wants expunction without costs. Right as soon as that verdict is delivered, the judge is supposed to ask the defendant if they want that charge to be expunged. And if the defendant says no, but applies for expunction later, the person might incur court costs. So that's something to keep in mind if you are defending somebody or in a situation where this could apply. And then another way a dismissal expungement may show up on criminal history sheets is a nolle prosequi, or sometimes you'll hear it called nollied charges, and orders of protection. So these two things are just a little bit different in that if a charge is nollied, it requires a petition to the court. And if an order of protection is, if a client wants to expunge something related to an order of protection. That order of protection had to have been denied by the court and successfully defended by your client and denied by the court to get that expunged. So moving on to the second kind of bucket, the one we haven't talked about related to expungement is diversion. So again, we're in 4032-101. That's the statute we're living in today. And the relevant parts that relate to diversion are in A and G. And so what is diversion? Diversion is when someone who has been charged with a crime is given the opportunity to complete some sort of alternate course of action to serve their sentence, we'll say. So this can look like a lot of different specialty courts or substance abuse programs or things like this. And when you successfully complete pretrial diversion, if you're looking to expunge a diverted charge, there is a clerk fee that applies. Again, you can submit that affidavit of indigency, but that clerk's fee is likely going to be charged under a different statute, 821-401. And an important note here is even though diversion may be a possibility for sexual offenses or possibly violent sexual offenses, you are not eligible for expunction of those. So this does not apply to successful completion of pretrial diversion programs for sexual offenses or violent sexual offenses. And those are defined at 4039-202 if you need to parse that out in more detail. Under 4032-101G, we're back in G. We're going to be talking about G a lot today. G is for eligible offenses. Sorry, I'm just checking that my audio is working here and on. I think it is. I hope it is. If not, I'll just re-record this after this. Anyway, it wouldn't be a presentation without a little technical glitch, huh? Under G, eligible offenses, we are back into the conviction bucket now. So again, just to review, the three buckets of expungement in Tennessee are dismissed charges, which can show up as a number of different things on a criminal history sheet, pretrial diversion or other diversion programs and successful completion of those is another bucket. And then the third bucket is convictions. And this is the most complicated bucket, arguably, but it's also an extremely important bucket, and it's where a lot of those folks who are likely eligible for expungement, but they have not had their charges expunged, are living in the conviction bucket. So what is an eligible offense under G? We touched on this a little bit. Certain E, D, and C felonies are eligible if they were committed after November 1st, 1989. Certain misdemeanors committed after November 1st, 1989. And then there's a different list of certain felonies and misdemeanors committed prior to November 1st, 1989. So what's up with the November 1st, 1989? This is when the criminal code changed, in case that date doesn't ring any bells. So it's an important year to keep in mind if you run into anybody who has a charge prior to 1989, and specifically November 1st, 1989, you want to make sure that you're looking at the right list of eligible offenses for convictions. So G2 talks about timing, and under G, you can only expunge on a one-time basis after the most recent sentence is served. So that's an important thing to consider if you're looking at a client's criminal history, you can only do this once under G. So keep that in mind as you're assessing everybody's case. There is, here's the breakdown of the waiting periods in Tennessee. So we've got a 5-year waiting period for misdemeanors and Class E felonies. And again, this waiting period starts after all sentence requirements are fulfilled. And we've got a 10-year waiting period for the eligible Class C and D felonies. Again, all sentence requirements must be fulfilled, including any outstanding court costs. And G2F, we've got an interesting nuance here. So if there is more than one eligible conviction that's part of a single criminal episode, all of those convictions can equal one conviction. So if you have a single criminal episode, what does that mean? It likely means an episode that happened at the same time, likely means it happened in the same location, likely means there was the same criminal intent behind the episode. So if you have something that looks like a single criminal episode, but there are several convictions related to that, it's possible that all those convictions can be grouped together as one conviction that's eligible for expungement under 4032-101 G2F. And in 2022, this was expanded, and the expansion is a little complicated, but hang out with me here. It allows expungement of eligible charges that precede an ineligible charge. So in 2022, when they made this amendment, they wanted to make sure that somebody with an ineligible charge wasn't completely barred from expunging something before that charge. So if you're looking at a criminal history sheet, you want to find any ineligible charge on there, and you're only looking prior to that to see what's expungible as a conviction under G. So again, the 2022 expansion of this statute allows eligible charges that come before an ineligible charge to be expunged. Say that 10 times fast. And just a little history note, before the Tennessee legislature added G to the statute in 2012, expungement in Tennessee was only available for dismissed charges. So 2012, this statute expanded eligibility immensely. And it's a really, really important expansion to keep in mind. A lot of people still think that if they have a conviction, they can't get it expunged. This has not been on the books for all that long, so it's really important to keep in mind that conviction expungement is a possibility under G. So moving on to a few other sections of 4032-101, we've got K, which actually does let you expunge 2 convictions. And there's a formula for the 2 convictions it can be. It's still a one-time process. So again, thinking about if we go back to G, G2 timing, one-time basis only. There's a one-time basis only here. And it's the same thing under K. It's a one-time petition, but you might be able to expunge 2 eligible convictions. What are those convictions? It's going to be 2 eligible misdemeanors or 1 eligible misdemeanor and 1 eligible felony. Where do you go for eligibility? You go back to G, to this list of eligible offenses. So K is just letting you combine 2 eligible misdemeanors or 1 eligible misdemeanor, 1 eligible felony. You can put those together and apply for expungement under K one time. So K expanded things even a little more. Moving on to 4032-101H, M, and O. We won't be talking about these too much. They're not super common necessarily. O is going to be the most common of these three. But H, B, and C talk about pardons by the parole board or the governor. Historically, it was only possible to expunge a record if you had a pardon by the governor. That's obviously, I hope, 30 minutes into this presentation, you know now that is not the case. You do not need a pardon from the governor. But if you do get one, 4032-101H may apply to you. Under M, the voting offenses have their own separate category of expungement, and voting offenses have a 15-year waiting period after the sentence is served. So if you run into somebody with that on their record, just know it's got a longer waiting period. It's got that 15 years that have to pass before a record can be expunged of a voting offense. Then we've got O, which is an arrest record without a charge. The problem with arrest records, if they were never charged, is there's actually no court record to expunge. So you have to go to the court and the DA and go through a process that more or less creates a record that you then have to expunge. The court then has to expunge. And very briefly touching on 4032-105, this is a much overlooked but potentially powerful part of the expungement statute in Tennessee, expungement for human trafficking survivors. So if somebody is eligible under 4032-105, what does that mean? It means there's only a 1-year waiting period after the sentence is served, as long as there are no further charges in that 1-year period. After the 1-year period, expungement is a possibility for a human trafficking survivor. There are a number of caveats. At least one petition for expungement must be for violating 3913-513, which is the prostitution statute in Tennessee. And we're back to G again. The convictions have got to be eligible under G, and no use, attempted use, or threat of use of physical force against person of another, and no use or possession of a deadly weapon. So there's a lot of discourse around whether this has actually meaningfully expanded expungement opportunities for human trafficking survivors, but this does exist in the statute. It is a tool we can use for folks who have experienced human trafficking. That 1-year waiting period is really, really huge. So if they are eligible, make sure that this is something that you are considering in clients. Let's move on to jurisdiction and costs. So we briefly talked about dismissed charges without costs, or quote unquote nollied. The jurisdiction comes in here. So the petition has to be filed where the case originated. And if somebody doesn't know, you can call the district attorney or the court clerk, and the DA is statutorily required to issue information on expungement. So they should not only be able to tell you where the case originated, but they should be able to give you information on how to expunge. Now, they're not going to hand it over and tell you if your client is eligible or not, but they are required to issue information on expungement. Depending on the charges, you may need a separate form for each charge. This is for dismissed charges. So looking at somebody's criminal history, there could be a number of dismissed charges. There could be 6, there could be 8. Make sure if you need a separate petition, a separate form for each charge, that you've got a form for every charge. And this is a question you can ask the court clerk, and they'll be able to tell you whether you need a separate sheet or not. Make sure you ask the clerk for a certified copy of the orders expunging the person's record and a certified copy of the charging document. Generally, the client has to provide a self-addressed stamped envelope for each form submitted. This might vary a little bit county by county, but generally that's something that the person has to provide in order to get those certified copies back. So after you submit a petition to the court, it will go on to the judge, and the judge will process it and forward it to the relevant agencies, i.e. TBI, so that the records, the appropriate records, will actually be destroyed in Tennessee. So this is something that also varies state by state. Not all states completely destroy the public records. Tennessee actually completely destroys the records after a charge has been expunged. So costs sheets, if somebody's got costs or if they've got a retired case, retired cases will likely have to be formally reopened by the DA and nollied by the DA. And if they're nollied, they're likely going to have costs. So just make sure any costs are taken care of before you submit a petition to the court. Again, you can submit an affidavit of indigency if this is an issue for your client, but just make sure that costs are top of your mind, because an expungement is not going to move forward if those costs are not taken care of or dismissed. So over on the right, we've got an example order for expungement. And as you can see on this one, it asks for the case name, the docket number, whether it's criminal or general sessions court. And then you've got the name of the person. And on this specific form, there are you can list up to 3 charges on this form. So if you had 5 dismissed charges that you were expunging, you would need 2 of these sheets, right? So you would put 3 of those charges on this sheet, and then you would fill out another form, even if it came from the same case, fill the whole form out, put 3 of the charges on here, 2 of the charges on the next case, and this will be you staple that together with a sheet that shows there are no outstanding costs related to any of these cases, any of these charges, and submit it to the court. Talking a little more about costs. So there can be administrative costs. The court clerk fee is generally $100. Today it should not be more than $100. And if there is a court clerk trying to charge more than $100, you may want to do a little research to see if you can ask them to bump that down to $100. If a charge was dismissed with costs, again, any of those costs are also due. And you need 1 self-addressed stamped envelope per charge. So, and by per charge, that means per charge. So even if they let you put 3 charges, like on this sheet, they let you put these 3 charges here, you're going to need an self-addressed stamped envelope for each of these charges, because they're going to come back as separate expungements. So other possible costs we have to keep in mind for folks we're working with, especially if these are folks experiencing poverty. They could have transportation costs. There could be parking costs. There could be childcare involved. They might have to take time off of work and incur lost wages to deal with these things. So anything we can keep in mind in any way we can mitigate these costs for our clients is a win, no matter how small, right? So just some notes on costs. Only diversion and conviction expungements have a clerk fee. There should not be a clerk fee charged for dismissed expungements, dismissed charges. As we've been talking about this whole presentation, indigency waivers are possible for court costs and diversion fees. Always keep that in mind. And always, always, always pull your client's cost sheet before submitting an expunction petition. Even if they tell you, I don't have any costs outstanding, pull the cost sheet, check it out. Costs like to hide in all kinds of corners. So just make sure that all the costs are taken care of before you submit the petition. So let's take a step back and just go step by step through what it looks like to work with a client on expunging a conviction. So we're specifically in the conviction bucket right now. We are not talking about dismissals, which are always expungible. We are not talking about diversions. We are talking about convictions. How do you expunge a conviction? Number one question to ask is if the conviction is an eligible offense. Where do we go for that? If you said 101G, you are correct. That list is in 101G. Again, make sure that the language matches what you're looking for. So if it's listing offenses, it's going to be in there. If it's listing ineligible offenses, it's not going to be in there. So just pay attention to that positive, negative language. We already touched on that. So number one, is the conviction eligible? Number two, is the conviction expungible? So in order to figure this out, you're going to pull the criminal history. And like we talked about, you're going to look for those ineligible convictions. And anything before that is where you're going to look for eligible convictions. So if you find an ineligible conviction, you don't have to look at anything after that ineligible conviction. Again, we're only talking about convictions. So if there are dismissals after that ineligible conviction, those are still expungible. Those are always, 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 always expungible. But we're in the conviction bucket. We're talking about only convictions. So you're looking for ineligible convictions and you're looking at dates prior to that ineligible conviction. Another step to throw in here, you're going to disregard moving and non-moving traffic offenses. What are these? The statute doesn't define them anywhere, but generally we've found that things like driving with a suspended license or improper lane change or driving without a license, the things like this are going to fall in the category you can disregard them. But again, just a side note, moving, non-moving traffic offenses are not statutorily defined, but they do explicitly exclude DUIs in the statute. DUIs are not expungible, so just forget about trying to expunge those. So, full criminal history. We're looking at the convictions before an ineligible conviction. We are disregarding the moving and non-moving traffic offenses, and we're looking for continuous contemporaneous events. So again, this is that same criminal episode that we're looking for, 101G2F. The criteria might include the same location, same criminal intent. So we're looking for those continuous contemporaneous events, the same criminal episode that we might be able to combine all of those charges into one and get it all expunged. And then finally, the question to ask is, are costs, sentence terms, including anything related to probation, and waiting periods, are these all satisfied? Are all of these three things satisfied? If they are, we can move on to submitting a petition. So let's take a look at a few examples here. So these are all made up clients. These are not real criminal history sheets, but this is what you might find when you pull somebody's criminal history sheet. So we're in the dismissal bucket first. We are looking at Bill Smith's record check here in Davidson County. This was from the criminal court clerk. And the CGIS data is going to be the criminal database that all of this information lives in. So Bill Smith, let's see what we've got here. We've got 2 cases. You see one on the top half here. This is all one case. This is all one case. So what do we have? We've got the charged offense is criminal trespass. It's a misdemeanor. And over here, we go to the case status. It's dismissed. Okay, so this is the dismissal expungement example. So we're only going to look at this dismissed case. Because if we go down here, we've got conviction. So we're ignoring this for now. We're just talking about dismissals. What did we say about dismissals? Say it with me. They are always expungible. So this Mr. Smith can get this criminal trespass expunged because it was dismissed. But always got to check for costs. Do we though? No. If you said no, you're right, because this is a dismissal and there are never costs associated with dismissal. So Mr. Smith is in luck. This is fully expungible. There will be no public record of his criminal trespass in November of 2022. So let's go on to how we expunge. How we expunge Mr. Smith's criminal trespass. So going back here, that might stick out to you. Wait, where was this possession of drug paraphernalia? Well, let's go back here. Oh, you know what, folks? We're looking at a different, okay, this is a different example. My apologies. We're still working with Bill Smith, so I was thinking we were doing just his criminal trespass, but it looks like he's been active down in Murfreesboro too. So we're in Rutherford Court of General Sessions now. This is a separate example. And so Mr. Smith, we've got arrest information here, disposition information here. So this is after we've pulled Mr. Smith's criminal history sheet, and he had 2 charges. Why are these 2 charges both on this sheet? Because they were part of the same criminal episode, right? So we've got criminal trespass and possession of drug paraphernalia that after we've looked at Smith's criminal history and Mr. Smith, this was part of a continuous contemporaneous event. So these are both expungible, right? The defendant arrest information is going to be separate from the disposition information. The disposition information is where this dismissal is going to show up. And then there's a separate, make sure you read all of these. This is where if it's dismissed, you choose the type of dismissal it was. So it's just straight up dismissal here under 4032-101. But here we see the other language that might show up for the dismissal bucket of expungements. No true bill, verdict of not guilty, appeal has been reversed, nollied, and then here's our diversion language. Successful completion of probation provisions and proceedings against defendant have been discharged, and suspension of prosecution is another category that we are not spending time on today. So, and obviously you leave this blank for the district attorney and the judge. Moving on to a diversion example. So we've still got Mr. Smith. Mr. Smith is now in Knox County, and we're looking at diversion expungement. So what are we looking for over here? Do we see a diversion over here? Dismissed, dismissed, nollied, dismissed. Here we go. See, you got to really look at these sometimes. Judicial diversion completed. So it's kind of hiding, right? It's in parentheses, it's abbreviated. If you're just glancing, it looks like a dismissed charge, but it's a diversion. Oops. So what does that mean? It means there might be costs associated with this. So that's something that we have to consider with this judicial diversion on here. The rest of these, what are they? They're in the dismissal bucket. No true bill, dismissed, 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 failure to prosecute, nollie, dismissed on cost, dismissed. Notice that he does have costs on here, so you want to make sure and pull Mr. Smith's cost sheet and see if those have been taken care of or not. But we're looking in the diversion bucket for this example. So here it's hiding right here. And what was the charge? Simple possession, casual exchange, misdemeanor. We would go to G, see if that's expungible. It's expungible. So what do? We fill out the order for expungement of a criminal record. Again, we've got the General Sessions Court of Knox County in Knoxville. We've got the docket number. We've got the case, the date the case was filed. If this were a circuit docket number, that would go here. And the information on the charge and the disposition of the charge, right? So final disposition, judicial diversion complete. And here we've got the diversion language checked. Okay. And finally, we are back in our conviction bucket. What do we see here? We've got a complete diversion. We've got a nollie. We've got a dismissal. Okay, here's a conviction. Let's see what else we've got. Dismissed, conviction, dismissed, dismissed. So we've got 2 convictions. So what's expungible here? I'll give you just a few seconds to ponder that. Which of these convictions, if any, or if both, are expungible? If you are thinking that the simple possession casual exchange is expungible, you are correct. So we've got a DUI as the other conviction, right? And what are DUIs in Tennessee? They are never expungible. So this is ineligible for expunction. But this simple possession casual exchange was a conviction in 2013. So because this is an eligible offense under 101G, it is expungible. Okay, so expungement in a nutshell. Say it with me. Number 1, dismissals are always expungible. Secondly, convictions. We go through 3 broad questions to figure this out. Number 1, is the conviction eligible? Number 2, is the conviction expungible? Number 3, has the client satisfied waiting periods, terms of sentencing, and costs? And then a question we always want to ask at the end of all of this, and again, this is a separate process in Tennessee to get things like voting rights restored, but we want to ask, can citizenship rights be restored? And then we want to do the work to make that happen for our clients if it's possible. Very briefly, what does it look like to plan an expungement clinic? So the Tennessee Supreme Court Access to Justice Commission suggests a number of things. They suggest that you start planning really early, 6 to 8 months in advance. They suggest that you partner with court clerks, judges, legal aid, DAs, public defenders, community volunteers. All these folks are good partners, and they may also help you with number 3, which is finding a venue. You need space to do a clinic, right? So you have to have space for registration. You have to have space for confidential attorney consultation. And if you have judges involved, if you're doing a night courtroom in an elementary school, for example, that's something that has been done. You need rooms that can serve as the courtrooms for the judges. The Access to Justice Commission also suggests that you circulate flyers for pre-registration and provide refreshments at the event. If you have that list of folks that have pre-registered, then that lets you pull their criminal histories and cost sheets before the clinic, saves a ton of time. And number 6, train the lawyers who are going to be there on the statute and provide templates for petitions, motions, and orders, including those affidavits of indigency, including the expungement sheets, including any other relevant motions that might need to be made. And then finally, develop beforehand a receipt for the folks submitting petitions with a summary of those services that have been rendered during the clinic, and then the appropriate court clerk's contact information to follow up. So, easier said than done, but the Supreme Court Access to Justice Commission has this laid out with very clear guidance on how to set this up. And after this CLE, you know the nuts and bolts of how to make it work. So that concludes this CLE presentation on expungement in Tennessee. Very briefly, our team at Tennessee Justice Center, I am Brianna Murphy. I'm a law clerk here at TJC, and I'm working under the direction of these 3 fine folks, Brant Harrell, Emily Jenkins, and Gordon Bonneman. And you are welcome to reach out to us with follow-up questions, or if you'd like to know more about anything specific that we didn't have time to touch on in this presentation, you are welcome to reach out to us. My email is b as in boy, b Murphy, Murphy at tnjustice.org. And here are those sources. We'll include those in a follow-up email we'll send out with some resources for you. So that concludes this presentation. Thank you so much for being here, for being interested in this, for helping our fellow Tennessee citizens regain the rights that they are entitled to regain after they have served their sentence. So with that, I will figure out how to stop recording this and leave you all to your days. Thank you again for being here, and take care.